We'll start the morning with case number 659 from the 2023 term, Bhargava versus Prince George's County Public Schools. Counsel, whenever you're ready.
All right. Is this on?
That should be on.
Now is it on? There we go.
Okay.
Good morning. Good morning. May it please the court. Alex Votaw from the Law Office of G. Macy Nelson, today representing citizen appellants who are attending virtually in today's case. Just to give the court an overview of the arguments I intend to address during these oral arguments, I don't intend to address in any detail the substantial evidence argument because I believe that's been adequately addressed in our opening brief at pages 20 to 37, as well as our reply brief at pages 11 to 12. Of course, I'm happy to answer questions about it, though. What I do intend to focus my arguments on is the jurisdictional issue raised by appellees regarding courts and judicial proceedings, section 12-302. I then intend to address the circuit court decision, and then after that, the planning board decision. The only note I would like to make regarding the substantial evidence piece is that the on-site versus off-site forest conservation requirement is a significant part of this case that appellees have never addressed in any meaningful way in their briefs, but we did address that in our substantial evidence argument in our briefs. So turning to the jurisdictional question, citizen appellants assert that appellees are incorrect when they argue this court lacks jurisdiction over this appeal under courts and judicial proceedings, section 12-302, because this court has jurisdiction in through four different avenues. The first is the Forest Conservation Act itself, which we argue under the Chesapeake Bay Foundation case, the Craig Westport case, that's 481 MD 325. The Supreme Court states provides appellants the express right to appeal this, the circuit court's decision to this court. We also believe that the county's ordinance impliedly gives us a right to appeal to this court through the grading permit requirements, and we've explained that in greater detail in our reply brief from pages 1 through 6. We also believe there are several common law avenues for jurisdiction in this court, including administrative mandamus, common law mandamus. Both of those would provide this.
If it's administrative, the argument is if it was administrative mandamus, then that would be the exercise of an appellate jurisdiction by the circuit court, and therefore there would be no appellate jurisdiction in this court. That's the problem, I believe, that the appellees have cited in this case.
Yeah, and I believe the Matthews versus Housing Authority of Baltimore City case, that's 216 MD App 572, addresses this issue, where it says that distinguishable from circuit court statutory review cases, which are not reviewable by appellate courts unless explicitly provided under case law, that under the section 12-302A administrative mandamus, actions brought under Maryland's Rule 7-400 are subject to review by the Appellate Court of Maryland. So again, I still believe the Forest Conservation Act provides us an express right.
Oh, help me with that.
Yeah.
I don't understand how that's possible.
From my understanding of the case law.
Don't talk about the case law. Talk about the statute. You're citing the statute.
Oh, the Forest Conservation Act statute?
I don't understand. There's no path of review out of the Forest Conservation Act statute itself, right?
So I would disagree with that.
Yes or no question?
I would say no, and for this reason. The Forest Conservation Act states that local ordinances, local governments are allowed to enact local versions of the state program. The state has its own Forest Conservation Act program codified in the Code of Regulations, and it says that the local versions have to be as stringent as the state version. And the state version provides an express right to appeal to the Appellate Court of Maryland. The local version is required to do that as well. And if it fails to do so, there's still that right under the Forest Conservation Act. And that's...
Yeah, you keep saying that, but where is that in the statute?
Yeah, if you could give me one moment.
Because what I think you're arguing is that the existence of whatever substantive rights exist under the Forest Conservation Act are then enforceable through the local approval procedures mechanism. And that, I don't see how that connects here.
I would state it slightly differently, if I may. I would state that the Maryland Code of Regulations provides the process for evaluating Forest Conservation Act plans, so tree conservation plans in this case, and Forest Conservation Act variances through the Code of Regulations. And in that Code of Regulations, the process describes an administrative review by, I believe it's the Department of Natural Resources, and then that decision can be appealed to the Office of Administrative Hearings, and then that can be appealed to the Circuit Court and the Appellate Court of Maryland under the Maryland.
But that's not what we're talking about here.
But
That's not the procedural path this case is on. This is in a totally different posture. So where is the statutory appellate right that you're claiming on the posture of this project?
I would argue, and what appellants are arguing, is that the Supreme Court of Maryland in the Chesapeake Bay versus Craig Westport case clarified that local ordinances must provide the same appellate rights as the state, and that those appellate
So now
rights.
you're back to where I was a minute ago, which is it's not a right that it's an appellate right that comes out of the Forest Conservation Act itself. It's an appellate right, if it exists at all, that flows out of the local approval procedures, and that's where I don't.
Again,
in other words, the local analysis of this project has to include recognition, the argument is, recognition of whatever rights or obligations flow under the Forest Conservation Act. But the procedural path that follows is a function of local law, not an appellate right coming out of the statute itself. This is why I think we're back to where you were with Judge Keough before. It's some form of mandamus. It can't be common law mandamus because there's no. This isn't a failure of a local official to carry out a statutory obligation.
well, if I may address that point, we believe that at the very least, the articulation argument requiring the planning board to provide a written decision would fall under that common law mandamus argument, that they do have a statutory duty that is not discretionary to provide a written decision for the.
Well, isn't that a matter of appellate relief, that the facts that there's an insufficient basis of fact to support the decision and remand for a discretionary determination of what facts indeed do support the decision, rather than write up a list of facts and any old facts will do?
I don't know that I would agree with that characterization. What I would say is that the planning board reached a final quasi-judicial decision, and Maryland's case law states, and we argue that the planning board's rules of procedure state that they have to provide a written decision memorializing whatever they found, and they failed to do that in this case.
Under the statute, natural resources statute, if they accept it, they don't have to say anything, but if they reject it, then they have to explain why they are rejecting. And in this case, they accepted it, so under the natural resources statute, do they have to say anything?
I'm not sure what specific provisions that you are referring to, so I don't want to overspeak about what I do and don't know. What we argue is that Maryland's case law is very clear. When an administrative agency makes any quasi-judicial final decision, like the one the planning board made here, they're required to provide a written decision that would allow this court to adequately review that decision. And the planning board in this case failed to do so.
I mean, that's not literally always true.
I believe it is.
It's true where the law requires it.
I believe Maryland's case law stands for the principle based on the Elbert case, for example.
Well, I was on the panel for the Elbert case.
I know.
And the Elbert case arose in the context of a local law that did in fact require a statement of written reasons. I'm just quarreling with the broad sweep of your statement. There are absolutely times across Maryland administrative law where a formal written opinion is not required.
Well, maybe I can narrow it this way. Every case that I have reviewed, and I don't believe the appellees have cited any cases that say otherwise, and specifically administrative review of land use decisions requires a written decision.
I'm not sure I would agree with that in a sweeping sort of way. I mean, there's 24 different jurisdictions worth of land use procedural law, and there's a lot of different layers of decisions. And I mean, we don't need to solve this today, but I'd be surprised if it were true that every single decision made by an agency in the context of a land use case requires a full-blown written opinion. If that were true, there'd be a ton of these approvals and denials that would violate that principle.
I think at the very least it requires any written decision, whether it's the planning board voted to approve and they did so on this date. The planning board didn't provide any written decision whatsoever. So this court need not decide the full scope of what the written decision needs to include. And again, this court doesn't need to address every single question or every single instance of an administrative land use jurisprudence, of course. But in this specific case, the planning board certainly needs to provide a written decision that this court can review. And if I may go back to the appeals question, whether or not this court has jurisdiction. Again, I still believe that under the Craig Westport decision, the court clearly states that there's a right to appeal to the same extent that the state applies it. But if we want to look just to the local ordinance, for example, the local ordinance says that Forest Conservation Act plans are appealable through the same process as the associated plan that they are aligned with. And in this case, that's a grading permit. And the grading permit process, while not identical in every single aspect, the appeal mechanism does allow for an appeal to the circuit court as well as the Appellate Court of Maryland. So again, that's another.
That's a different permit.
Yes, but the Forest Conservation Act in Prince George's County states that the appeal rights are predicated or based on whatever related permit the Forest Conservation Act application is applied for. So in this case, the Forest Conservation Act permit or application, the Tree Conservation Plan and the Forest Conservation Act variance was associated with a grading permit. So if the local ordinance, if we're going to base it solely on what the local ordinance says, the local ordinance says, look to the associated plan for the appeal rights. And in this case, the grading permit is the associated plan. And under the grading permit appeal rights, there's a right to appeal to the circuit court as well as a right to appeal to the Appellate Court of Maryland. So that's, again, we believe there's several different avenues for appellate jurisdiction in this case, but that would be one of them if we were to narrow our scope just to what the local land use or what the local ordinance says on its face. If that answered the court's questions, may I turn to the next topic?
Well, I hope one of the topics you're going to address is mootness.
Yes, absolutely. That is what I'm getting to right now. So we believe that this court's, the standard of review is to look through the circuit court's decision, but I understand the court wants us to address the mootness, and I understand the appellees have argued this court looks at the circuit court's decision with abuse of discretion. So to argue in the alternative, even if this court were to adopt that standard of review, the abuse of discretion standard first asks this court to determine whether or not the circuit court has made a legal error in its determination. And we assert the circuit court made legal errors when it evaluated the substantial right piece as well as the mootness piece.
The substantial right piece, Judge Grayson Kelly said that they have no substantial right to continued existence of the specimen trees, which raises a question as to what right does someone have to trees on someone else's property?
And exactly to that question, we believe that's not quite the right legal standard to apply to administrative mandamus cases specifically for land use agency decisions. Because we believe that the Long Green Valley case, that's 205 MDAP 636, stands for the principle that when this court is tasked with reviewing an administrative agency's decision related specifically to land use decisions, that the appropriate legal standard in that case to determine substantial rights impacted by the decision is the property owner aggrievement standard, which this court has developed fully in its land use jurisprudence.
The statute under 25119 F2 specifically, or F5, talks about this is not, or I'm sorry, F4, variances are not to be considered zoning variances. And 25119, the notice requirement is to DNR, and in 27130, it talks about the effect of the application on other neighboring properties. So there's a fundamental, it appears there's a fundamental distinction between 27 or 25-119 and 27-230.
Yes, I wouldn't say yes. What I would say is Maryland's land use jurisprudence is not limited just to zoning case law. It includes any land use decisions. That can include agricultural preservation easements, that can include critical area law, and in all of those circumstances, when the court is evaluating writs of mandamus about those cases, the legal standard specific to the substantial right piece is property owner standing, meaning you have a substantial right impacted by the planning board's decision if you can satisfy the property owner standing piece. So we would argue
that's a whole nother path. There isn't any showing where Ms. Bhargava is aggrieved differently from the public, is there?
Yes, I would argue that there is. But before I answer that, do you want me to answer that now, or would you?
Answer that now. That'll be on us, and then you can decide if you want to use up any of your remaining 5 minutes.
Okay. Okay, thank you. So as it relates to Mrs. Bhargava and whether or not she's aggrieved differently than the general public, again, we believe the correct standard is property owner standing, where Maryland's.
I know, but that's how you get property owner standing. You
Well,
either have to live in the zone that's directly affected, or you have to establish an injury that's specific to you, different from the public.
Yes. And so in this case, she is living in the zone impacted. Under Maryland's property owner standing aggrievement, you are prima facie aggrieved or prima facie impacted by the decision if you live adjacent to the property.
Under zoning law.
No, that's general property owner standing, which applies to, as I believe, critical area law, agricultural preservation. What was that?
These are zoning cases, and the statute specifically says these are not to be considered zoning cases. And in the statute, the only entity that gets notice of the decision is DNR, is the Department of Natural Resources.
If I may address that with 2 points. First and foremost, the critical area law and agricultural preservation law, neither of those are zoning laws. Those, for example, in Prince George's County are in different subtitles than the zoning ordinance. Those are different areas of law, but they're still land use decisions. And in land use decisions, the court, for example, in Long Green Valley, held that the appropriate standard is the property owner standing, where you are in close proximity to that site. And to your point about the statement about zoning variances and Forest Conservation Act variances being not the same, we argue that we don't believe that demonstrates legislative intent that they be treated under different legal standards when evaluating the criteria or for standing. We assert that it's more reasonable to assume that that provision provides guidance as to the procedural issues. So, for example, you noted that there might be different notice issues for a Forest Conservation Act variance and a zoning law variance. And because these two are interrelated, they're often evaluated at the same time, a zoning case and a Forest Conservation Act case. We believe that provision serves instead to clarify that if you're going through this process and you need a variance, you need to apply for both a Forest Conservation Act variance, for example, and a zoning law variance. Those vary or impact different case laws, but they might share very similar criteria, if not, but they don't necessarily share all the same criteria. Or, for example, in the Forest Conservation Act variance, they're approved by sometimes different entities at different stages of the process. So we believe that, for example, if you look at the Craig Westport case, the court describes how closely related the Forest Conservation Act law is the critical area law as well as the zoning law. And so we think that provision instead serves to clarify that there might be some procedural differences associated with a Forest Conservation Act variance in terms of who can approve it and the scope of the variance, but it does not necessitate that different legal standards be applied to, for example, who has standing to appeal or the legal interpretation of the provisions of the criteria for the zoning ordinance.
I would appreciate it if before you sit down, you would spend 1 minute telling us why this case is not moot.
Absolutely, I would love to, and in fact, I would be happy to do.
You can do that on us. What I don't want, because I know your counterparts are going to get up and tell us that it's moot, and I don't want to hear from you for the first time on that on rebuttal. So
yes,
the time is on us, but please
Thank
tell
you,
us quickly why the case is
yes.
not moot, because it seems like it's awfully moot.
Yes, so it's not moot because the standard that appellees argue for and the standard that the circuit court applied for is a legal standard appropriate for perhaps an injunction hearing. But it flies directly, or contradicts directly, Maryland's long-held principle that in land use decisions, again, critical area law, zoning law, agricultural preservation, that the developer who acts on an appeal or on an application that is subject to judicial review does so at its own risk. And according to the Powell versus Calvert County.
How is it that we could afford your clients any relief here? And to the point you made a minute ago, isn't the answer, if they bulldoze trees they shouldn't have bulldozed, isn't the answer that that's addressed by an enforcement action under the Forest Conservation Act rather than a challenge to the permits for a building that's been housing school children for what, a year at this point?
No, I would not agree with that statement, Your Honor, respectfully.
Well, it was a question, not
yes,
a statement.
Yes.
But what conceivable relief can we grant you?
Yes.
Even if we agreed with everything you said, what relief can you get out of this appeal, even if you win it?
The relief we're asking for is reversal or vacation. And if
what can we grant? I know what you're asking for, but
yes.
What can we actually give you?
You can give us, so let me walk through it if I may, Your Honor. If you reverse this decision, there's two parts to it. The first is on-site versus off-site forest conservation. That's a significant part of this case. And the applicant can provide more on-site conservation than they've provided currently. It doesn't matter how many trees they've removed. The second part relates to the specimen trees. If this court were to determine that the planning board erroneously approved the planning board, the tree conservation variances, that's it. That's the end of the analysis for the court. It would then be up to the county to determine what specific enforcement provisions to apply to the applicant. Respectfully, that part is not within this court's jurisdiction at this time, and it's not what we're requesting.
Right, that's the enforcement.
But you can't. We can't.
I'm stuck on what it is we can do for you and your clients, even if we were to agree with literally every other argument.
So it would be to reverse the decision, and I know that I don't want to repeat. I'm trying to provide more detail. So if you reverse the decision, that is the only way the county can imply or enforce those enforcement provisions. And that's the first step.
Why is that true? Can't the county find that it violates the state of the building?
No, because the argument we're making is that the tree conservation plan or the tree conservation variances were incorrectly approved. And then if they were removed.
The trees are gone, and the building's there, and the kids are finishing the school year.
Yes.
And we can't wave a magic wand and take that building away. So what, I mean, I ask it for the fourth time, what actual, an opinion issues from this court, what relief is available to you?
Again, and I don't mean to, repeat the same thing, but we believe
maybe I'm just missing it, but what is the relief you get if you win?
The relief we get is the planning board decision is reversed, and then that would trigger.
But how is that relief for you?
If I may explain, because that would trigger the county's enforcement to be able to say, you remove these trees illegally, here are the steps that you have to take. But it's only the county who can determine what the next step is. If I may provide an analogy that hopefully would be helpful. If an applicant, for example, had a variance to install a large fence, for example, and it exceeded the permitted height unless you had a variance. And they already installed the fence. It's too late. The fence is already installed. If the court were to determine that the decision to approve that variance was erroneous and they reversed that decision, that's the end of the court's obligation in this case. Then it would be up to the county to determine how the property owner in that case would be required to meet the requirements, whether that's cut your fence in half, whether that's pay a fine, whether that's remove the fence entirely, whether it's install a new fence. The only step that the court can take is to reverse or affirm when we're talking about judicial review or writs of mandamus of an administrative agency's decision. It is then up to the county to determine what specific provisions would be appropriate. And again, we believe that if the court were to find it is moot, for this very reason, then it falls directly within the public concern exception, because no tree conservation plan, no Forest Conservation Act variance would ever make it to judicial review, because the property owner would be incentivized to remove those trees immediately. And as we pointed out, sometimes property owner notice is not required, even though there is an appeal right. So we believe that all of those circumstances, again, the appropriate relief is to reverse or vacate, and then it's up to the county. That would initiate the county's process. The county cannot issue a violation until that occurs.
And that's because the current state of the record is that the tree plan's been approved.
Mm-hmm.
So
exactly.
if the county were to initiate an enforcement action, the argument would be that's stopped by the approval of the...
Exactly. And the county doesn't have the authority to, the enforcement branch of the county doesn't have the authority to render that decision illegal. It's only this court who has jurisdiction to do so.
Okay. All right. Any other? Okay. Thank you.
Thank you very much.
We'll have 5 minutes on rebuttal. Mr. Warner?
May it please the court, David Warner, principal counsel for the Prince George's County Planning Board, a constituent arm of the Maryland National Capital Park and Planning Commission. Quick question for the court. The attorney for the school district here, Ms. Moriarty, was going to address the issue of mootness and the jurisdiction of this court to hear this case. Would you like her to go first, since that's kind of the topic?
Yeah, I think let's talk mootness and jurisdiction.
All right.
Sure.
Yes. Why don't we flip you then, if that's okay?
Good morning, Your Honors. May it please the court, Nicole Moriarty of the law firm Kutak Rock on behalf of Prince George's County Public Schools, the applicant in the underlying proceeding. Why don't I start with the appellate jurisdiction, and I'd like to address the Craig Westport case and the FCA, since that case addresses that statute as well. But Westport was a narrow case that focused on local Hartford County procedures in a private development case. In fact, the court expressly stated at 481 Maryland 325 337 that the sole issue in dispute was whether the approval of the Forest Conservation Plan in that case was a final decision and therefore subject to petition for judicial review pursuant to the appeal process established in the Hartford County Code. So Westport does not require a finding of a right to appeal for appellants in this case, and the court in Westport recognized that the Maryland Forest Conservation Act requires local conservation programs to provide an appeal process, but the court did not find, as the appellants have suggested, that Prince George's County must provide the same appeal rights as provided in the state version of the FCA. In fact, the court in Westport recognized that the FCA's implementing regulations expressly state at COMAR 08.19.02.02.c.3 that the hearing and appeal procedures included in a local conservation program, quote, must be consistent with local appellate review procedures. And then the court in the Westport case focused specifically on Hartford County's procedures, which in that county expressly provided for interested persons the right to appeal approvals related to private development. But as the court recognized in Murrell versus Mayor and City Council of Baltimore, local Prince George's County law does not authorize ACM appeals in all cases. And additionally, as the Planning Board has pointed out in their brief, the WCO here allows the applicant to appeal a decision of the planning director. There is no express appeal right for third parties or generally interested parties in connection with the TCP.
The public, how can members of the public then hold the agencies to account to make sure they've dotted their I's and crossed their T's if there's no right of appeal? If it's just an internal conversations, as it were, between the county government and the Department of Natural Resources, how can the public hold these agencies to account?
Well, so this case, because it was a public project, was subject to the mandatory referral process. So there's not technically an approval of the development by the planning board, which I'm sure Mr. Warner will speak to, but there is a mandatory referral hearing where there is a public notice and opportunity to be heard, in which these appellants participated in that proceeding over several hours and were given an opportunity to be heard. They were also, able to identify, they live in the neighborhood, they see the development, and as in this case, were aware of the conservation plans, requested a hearing, and were heard extensively on the matter. But I do think that fundamentally in this case, what we're struggling with the remedy and everything, really does speak to whether they have a substantial right in these proceedings.
Before we get to that, though,
Yeah.
You didn't answer Judge Keogh's question. Okay. The FCA applies to this project. Your answer to Judge Keogh was, well, they had a hearing at which they had the opportunity to be heard. But you didn't say anything about when in the process there's an opportunity for the agency's decision to be reviewed or checked, right? If what you're saying is, well, there can be a hearing, but it doesn't matter what anybody says because we're going to go ahead and chop down the trees anyway, that doesn't seem to square with how the law ought to work. So maybe a slightly different way to ask his question is, when is it that they would have, should have, could have appealed the decision, challenged the decision to bulldoze these trees?
Well, I think in all administrative cases in jurisprudence, and the reason I bring up the substantial interest.
Just answer it in the life of this project. This project depends on the elimination of a bunch of trees. You said there was a hearing at which they had the opportunity to be heard. Okay, planning board decides to allow the project to go ahead. You said the planning board didn't even have to do that. When in the life of this project do the appropriate plaintiffs, whoever they are, have the opportunity to challenge that decision? If the answer is they never do, then say that.
Assuming an interest, they would go seek an injunction to prevent the construction from proceeding. The administrative mandamus statute exists because it's there when there is no statutorily provided right to judicial review. But the administrative mandamus standard.
There is no place in the administrative approval process for them to challenge the tree decision.
Well, the planning board at their hearing recognized that they could have sought a restraining order and injunction to prevent the construction to allow their mandamus action to be heard. So
I'm going to ask it again. In the life of the administrative approval process for this school, are you saying there was no place for them to get relief on the tree decision? That their only relief would be to bring a separate administrative mandamus decision and to seek injunctive relief, to stop the construction in parallel? Is that your position?
I think that may be the case, that not every member of the community can go say how the WCO.
We're not. Is there literally anybody? Imagine the perfect plaintiff, all right? Or maybe you're going to tell me there isn't anybody. Is there anybody in the world who could have raised a challenge to this tree plan in the administrative approval process that led to the construction of this school? Is there anybody in the world?
Mr. Warner, it is his area and his client and his statute that he
I know, but you're the one who's here to talk about this. I mean, we can tag team,
I do think that you have to have standing.
Look, you're allowed to split the argument.
Right.
But if you're going to come up here and say, look, well, I'm here to talk about jurisdiction and mootness, but I can't answer the question about jurisdiction and mootness, then you're not helping us.
Well, all I'm saying, though, is I don't know that there is.
You're saying there's no right in the world to appeal anything, And I'm trying to really
For
understand
a
if that's true.
member of the public to come and say how the conservation measures are to be decided on property owned by the school board, determined by the planning board under their technical expertise under the WCO, they're administering our property rights as it relates to our land. So I don't know that it contemplates a procedure for someone to come interject themselves and question the judgment of the planning board.
Every other land use case in the world has opportunities for at least people with standing to challenge the decisions of the planning board.
We would argue that this
And
is
you're
not a
saying-
land use case. We think that that has been briefed in the record below, that this is not a zoning case, but is also under the WCO and the mandatory referral process, narrowly focused on how the tree conservation and the WCO ordinance was administered on this project.
Who in the world, on what posture, has the opportunity to challenge the decision to bulldoze these trees?
I don't believe that the statute affords that right to anyone who doesn't
anybody.
have an interest in the property and the project.
That's not what I asked you. Who in the world?
I don't know the answer.
Well, who would?
Mr. Warner would.
So how is it that we can, how is it that we're supposed to credit? I mean, when these cases come up, there's always a lot of complexity to who's got what right to challenge what in administrative law. And it's different in every county, and there are always a lot of twists and turns to it. But there's always a place somewhere in the life of the project where the right people, whoever they are, have the right to challenge the decisions that are being made by the administrative bodies along the way. Now, the one thing that's different about this case is that it's the Prince George's County Public Schools building the building and not some private or commercial entity.
Right.
But what you haven't said in so many words, but what I keep hearing is there isn't anybody who gets to challenge the tree plan in this case at any point between conception and construction. Is that the answer? Is that your answer?
That is my answer. I appreciate the frustration.
How is that possible? How is it possible that nobody anywhere in the world has the right to challenge the application of this state law to this project?
Respectfully, Your Honor, we came prepared to argue why these appellants haven't met their standing requirements.
We'll get to that distinction. But I'm still stuck on the idea that nobody has the right to challenge it. Is that your position? Literally nobody in the world. If nobody in the world does, then they don't either.
My position is that I am prepared to argue whether they have the answer.
So you're not going to answer my question.
I am not aware of a provision in the procedure for this law that gives somebody the right to come in and question without any substantial right in the property of their proceeding.
All right,
So
you're dodging the question.
I apologize. I'm not.
Because
That is my
you keep
position
adding the
because
substantial right gloss that I tried to solve in the hypothetical, right? And you keep dodging it. So you can either
if someone
answer,
had a
you can either
substantial
answer or
interest.
you don't,
right.
all right? Is it your position that nobody in the world has a substantial right?
No, if you have a substantial right, then I
Okay,
think
so
you follow
who would
the
have a substantial right here? Who could
property
possibly?
owner has a
Okay.
right in whether it's denied.
Okay, who else?
I'm not aware of any other parties that have a substantial right to how we maintain trees or not on our property other than
So nobody
that.
has the right to challenge the tree plan in this case.
That is my position, and I want to make sure, unless you would like me to continue, that I leave 10 minutes for my colleague.
We'll take care of your colleague's 10 minutes.
Okay.
But you understand why the position you're taking seems very extreme. The law exists. You're saying that that you have the right to do whatever you want with the trees, notwithstanding the Forest Conservation Act, and that literally nobody in the world has a substantial right to challenge your decision on the trees.
No, I'm having trouble divorcing anyone in the world having the right with someone having the substantial right, and I don't have an example for you of who has that substantial right
When you're going
other
to try
than
to
the school
distinguish
system.
people, you have to understand the principle that drives this, right? So if you're going to say they don't have a substantial right, you have to understand who might.
And I can
And you're
just.
saying we do because it's your property and your trees. And now I'll ask it one more time. Is there literally anybody on planet Earth who would have a substantial right that could support a challenge to the Forest Conservation Act plan in this project?
I don't know of such a person.
So what it means then is your position is your client can bulldoze the trees and nobody could ever possibly challenge it.
Well, certainly not, because they are subject to the requirements and the standards
Yeah, but
set
it's not
forth.
enforceable by anybody.
there is-
If they decide to bulldoze their own trees, your position is nobody has any opportunity to stop that from happening at any point, because nobody has standing, nobody has a substantial right, nobody can challenge anything, nobody can touch it, right? The trees are gone, and then he's going to say it's moot. So how is the law ever supposed to get enforced or checked? I mean, in the approval process, where is anybody supposed to pay attention to the tree? I feel like the Lorax here. At what point in the life of this project does anybody pay any attention to this legal requirement to conserve forest? Your answer is nobody. If we decide to bulldoze our own trees, nobody can say anything about it. That's not how you would articulate it, but procedurally, that's the result.
It would be the same avenue that you would challenge any government official in them executing their job faithfully and according to their authorizing statute.
Yeah,
So
except the
if
trees
they're
are gone.
approving, then you would go seek an injunction to have their authority challenged for them not exercise.
How are they supposed to?
If you don't have
In this
a
case,
standing to assert an administrative right, what right do you have to an injunction?
Right.
What property, I mean, what you're saying is there's no property right. So how could a third party get an injunction if they don't have some recognized right to come before
Right.
some government agency to say, you're not doing this right?
Or a court. Who's got standing to bring who's got standing to bring the mandamus action to get an injunction in circuit court to stop the trees from getting bulldozed? Name anybody in the world, anywhere, who in your view would have standing to bring that that suit for injunctive relief and have the court consider it and grant it.
well, it would be someone who has an interest different than the general public.
Okay, who could that possibly be?
It's someone who was harmed in a manner that's,
Don't give the generalities. Like, name a kind of person. Someone who lives on adjoining property, someone who is a local arborist. Who?
I apologize, I'm not able to come up with an example of the person.
Well, but this is what you're pointing to. You're saying the only relief is to find somebody to bring that suit, and now you can't articulate a principle about who could bring it.
Respectfully, I am here to argue that they don't have the standing to bring the suit and that they don't have a substantial right, and there isn't a remedy to address the harms that they've identified as their individualized harm.
Is that just because they're no different from any other member of the public?
I guess part of why that is true is because they've created this false dichotomy of what the relief could be is even a hypothetical earlier situation where the trees remain. But even when they talk about on-site versus off-site preservation, when they determine the amount of on-site mitigation, the WCO and the factors that are considered on whether development can occur on a property would not have yielded a result where the entire 30 acres had to remain forested and none of the impacts that they've complained about would have reached them.
I don't know if that's true or not. You might be right. And let's assume for the moment that you are, okay? But the posture right now is that the planning board has approved this tree plan. And if the county or the state or anybody were to come in and say, this development violates the Forest Conservation Act, you're going to say, estoppel, right? We have an approved tree plan. But it's this circular process where we get to come up with a plan, Forest Conservation Act be damned. Nobody can challenge it. Nobody can stop it. Nobody has standing to get an injunction. And once the trees are gone, it's moot. That leaves a completely toothless standard. And what I've been trying to get any of you to explain is like, who in the world, anywhere, would have the ability to put a check on that? And you keep saying, well, I'm here to talk about something else.
Well,
and
one
that's
other
fine.
thing that I'd like to note that I think I should have noted earlier too, is that as council has acknowledged, this tree conservation plan was required in connection with the grading permit. The grading permit is what allows the trees to be bulldozed, not the tree conservation plan. The tree conservation plan is a technical document. These appellants, as the record reflects,
Okay, but if
challenged the grading permit. They filed.
If your grading permit violates the Forest Conservation Act, it shouldn't be approved, right?
But they initiated a challenge to the grading permit, and you heard her cite to the law that gave them the ability to do that. They voluntarily withdrew it, pursued the challenge against the tree conservation plan and another against the Maryland Department of Environment for the non-tidal wetlands permit that was granted. That was also denied for failure to have a substantial
Okay, so
interest.
your answer is that if they had stuck with the grading permit challenge, then there would be
In terms of
an opportunity for some agency or some court to actually consider the merits of the Forest Conservation Act plan and issue relief?
We're talking about proximate cause. You've asked who can stop these trees from being bulldozed.
I asked you a very specific question.
Correct.
You can answer whatever question you like.
If we need somebody who can stop the bulldozing of the trees, they would need to challenge the grading permit.
All right, stick with me, all right? You just took issue with them a minute ago for withdrawing their challenge for the grading permit. That may be their tactical mistake. We'll deal with that. Let's say they had stuck with their challenge to the grading permit, okay? In the life of that challenge, would there have been an opportunity for some agency to stop, to say, wait a minute, this grading permit violates the Forest Conservation Act, or whatever other authority, and it should not be approved, and on these issues could have been addressed on the merits?
Conceivably, since they can't issue the grading permit without a valid TCP, that they would have been able to look at, say, you have an invalid TCP, and through that process, and maybe the grading permit is treated with a different standard for aggrievement or what have you, where you would have someone conceivably who could say, I am here with the right to say that that wasn't done properly.
Who issues the grading permit?
DPI, the Department of Permitting and Inspections within Prince George's County, a separate agency, held its own administrative proceeding, came up with a stormwater concept plan, reviewed what would happen if these trees were removed from the property, and granted the permit.
And your position is that that grading permit opportunity is where the Forest Conservation Act issues should have been considered. Your colleague is shaking his head, so I don't think that's the right answer. But look, I'm just trying to understand where in the world this state statute is supposed to get enforced. And if your answer is it's not, because we're the county schools and we can build whatever we want, state law be damned, then say that and we'll decide if that's true. But I don't understand how that possibly can work in normal life, unless there's some overarching exception for public development that means it's not subject to state law. And I'd be surprised if that were the case.
Likewise, I think we should hear from the agency whose authority we're discussing is being checked.
Okay, can you give us 1 minute on why this case isn't moot, or is that his job too?
No, I can give you 1 minute on why this case is moot. So
Is or isn't moot?
it is moot, yes. So,
Because we bulldozed the trees?
well, appellants, have attempted to articulate a potential remedy in connection with their claims for the first time during this appeal. And they've done so, as you've noted, by referencing the WCO's general mitigation and enforcement provisions applicable when the planning board determines that a WCO violation has occurred. But this remedy is both unavailable and insufficient and should be rejected.
Why is it unavailable? Let's say
Well, two reasons.
If the approval should not have been granted because it violates the Forest Conservation Act, and yes, the trees are gone, But as you say, it wouldn't have ever been the case that the Forest Conservation Act would have required the whole property to remain forested anyway. Why isn't it possible that there could be relief in the form of a direction that you go plant trees somewhere else, or pay a tree fine, or do the things that happen all the time in these cases where there's some, you can cut down these trees, but you have to plant other trees somewhere else? Why isn't that? Yes, I know the kids are in school. Maybe today's the last day. I don't know. But you could, someone could still be ordered to do all of that. Why is that not a possible remedy here?
Two problems with this remedy are, one, that it would not resolve the harms, the individualized harms that these appellants claim they have suffered. So again, while you could reforest potentially on the margins, it would not bring back 30 acres of site, which is what they claim they're harmed by no longer having available to them. And the second issue is that them relying on the planning board's enforcement authority under the WCO demonstrates that the result would be, the remedy being sought would be directed at general conservation and at the benefit of the public in general, and not designed, again, to address their injuries. And those provisions don't offer a private right of action. So they're coming in seeking to have the enforcement provisions be their remedy when it doesn't remedy the harms they've identified.
But that's pretty circular too, right? You bulldoze the trees and they say, well, your harms are the trees, so sorry, can't help you, right? Like then the incentive is to just build the school and get the kids in it, and then say, oh, there's nothing we can do about it.
So in this case, there were 22 acres cleared, and there were more than double of that conserved in the county. So we met conservation goals and requirements under the statute.
That's the merits. You may or may not be right about that. I don't know, but you're saying we can't even consider any of that.
No, but again, it speaks to the harm. So there hasn't been.
No, but you're trying to say they're not harmed
the remedy,
on the merits as a way of saying they're not allowed to even challenge this. How can I consider any of that?
They do have to, under 7403 of the statute that supports their action, the administrative mandamus statute, have a substantial right potentially prejudiced by these actions. So it is related, and that the mootness cannot resolve what they complained of because they don't have any legal entitlement to continue to receive shade and benefits to pollution and oxygen levels from us having 30 acres of trees next to their property.
But again, your answer is there isn't anybody who does have a substantial right to challenge this. Right?
I don't have an example I can't come up with a person. Correct.
All right. Any other questions? Okay, thank you. Mr. Warner? Your position, the school can just build anything it wants and isn't subject to state law?
No.
And how is it this is ever supposed to get considered and addressed?
The question you're fighting over today, not fighting, trying to figure out, is the same question we faced in 2021 when this case came up, okay? In 2021, we had this mandatory referral hearing. The school is trying to build a school, right? We don't have any zoning or subdivision control over it. But we do have this right to have this mandatory referral hearing. We have it, about 8 hours long. All of the appellants show up. We don't want this school. This is traffic. This is going to cause environmental damage. It's going to flood. Fine. All those issues are brought up. We address them through the planning board. What they can do is they can make recommendations to the school and say, hey, you know, you should think about this issue. They were quite upset with the school in certain cases, said you should have reached out to the community more. All of that was occurring. During that case, it was mentioned that, oh, there's also a tree conservation plan under a different ordinance, subtitle 25 of the Prince George's County Code, that requires you to get a tree conservation plan in furtherance of the Forest Conservation Act. Oh, well, what's that all about? Mr. Nelson sent me a PIA request and said, what are you guys approving? I want to see that. We showed him pages and pages of written decisions made by the planning director approving the tree conservation plans. And he says, well, I'm going to appeal that. And we're like, I go to my environmental planning staff. I said, do neighbors appeal tree conservation plans? They said, well, we've been doing these for 25 years. No one ever has. And so I look at the statute that Prince George's County has, and it says appeal of decisions made by the planning director may be made to the planning board in conformance with 27289C8, a section of the zoning ordinance. I'm like, oh, good. I'll go to the zoning ordinance and figure out what the process is. You go to the zoning ordinance, and that section says nothing about appeals. It's about a limited, minor, detailed site plan, and it just says you have to provide your plans in a certain amount of time or something like that. So I'm like, I got no idea, and I'm new on the job. So I advised the planning board. I say, well, you know, I don't know if they have a right to appeal or not. But, you know, the planning board had an 8-hour meeting on the mandatory referral, saw all these concerns with the neighbors about this project. The planning board is not merely, you know, an administrative hearing officer, and all they do is have quasi-judicial hearings. They run the entire county's park system. They own all the parks. They do all sorts of things that aren't quasi-judicial. We talked to the chair at the time, Betty Hewlett, and I said, what do you want to do? And she said, well, let's give them a right to come to the planning board and make their case. Fine. So we do that. We have a hearing. That's 3.5 hours. Mr. Nelson appears on behalf of the appellants. Anybody who wanted to sign up to speak on the issue showed up and spoke. Ms. Moriarty spoke on behalf of the school. Our staff gave, you know, background on why they approved the tree conservation plans. And the board, as opposed to some cases, you know, where the board's kind of like, everything's fine, we'll go, they engaged in a tremendous amount of back and forth with the applicants, with the opponents, as to whether this tree conservation plan was appropriately issued or not, and whether these variances were appropriately afforded. And in fact, 2 of the board members were quite upset with the process and really said, you know, you should have saved a couple of these trees, or you should have rethought about moving a couple of them, because there were 11 specimen trees that the school needed to get a variance for, to get approval. And so all of this dialogue went back and forth. They decided to, one of the members made a motion. You can look at the transcript of the case from about pages 180 to 189 of the transcript. Each member gave an explanation as to why they were voting yes or no, and came out 3-2. So I thought, well, okay, we're done. But we weren't done. Mr. Nelson then filed a petition, initially a petition for judicial review. And he didn't cite any authority that gave him the right to file that, but he just filed it. So, you know, we all agreed to participate. And then I think what probably happened is he realized I don't have a right, so I need to make this a writ of administrative mandamus, because when you don't have a right to petition, you can choose this path. So that's how he styled his complaint. And we had the case before the circuit court, which is all laid out in the circuit court's opinion, obviously. And he brought all of these issues to the court that claimed that they had a substantial right that was prejudiced by the decision of the planning director to approve these tree conservation plans and these 11 variances. And, you know, we obviously had a full hearing where we went through all of the appellants' rights, everything that they claimed. And, you know, you can look at all of the appellants' arguments right in the reply brief that Mr. Nelson submitted to this court in the first appendix. You'll see the 3 affidavits that list maybe 20 concerns. They're just copies. 3 different people, Mr. Majors, Mr. Sutherland, and Ms. Bhargava, submitted the same complaints. But you'll see there's like 20 or 25 complaints, all the kind of complaints that, or concerns that anybody would have that lives next to a piece of property for 20 years that's forested, and then finds out there's going to be a school there. They're like, well, I don't want the trees to go away. I love looking at these trees. It's aesthetic. It's going to ruin my property values. Well, when you take the trees away, we're going to get flooded. You know, and some other interesting ones about, well, we like to walk through those lands, and now we won't be able to walk through them. I mean, a lot of concerns. I don't say they're not legitimate, that the kinds you would have, as anybody would have next door. They just aren't the concerns that the planning director had any authority to address when she was approving the tree conservation plans, because the Forest Conservation Act, as this court said in the Westport case that both parties have cited, says the act's purpose is to make sure that when development comes along in this state, that we do not lose trees as a result of development. We don't want clear cutting anymore. Or if you're going to clear cut, you're going to have to do something to address it. And that's what Ms. Moriarty was referring to, that this property had 29.7 acres of trees. At the end of the day, there will be 51.9 acres of conserved woodland at the end of this project, because they have to protect woodland other places in the county where they couldn't protect it on their property. And what's difficult with a tree conservation plan is an applicant comes in and they want to, and this is this West Montgomery case that's in our brief, and they mention it in passing in the appellant's brief, explains how this is difficult. In that case, you've got a guy coming in, he wants to subdivide his property, build 2 houses. It's got a bunch of trees on it. Now, the state could have said, you can't cut down trees anymore. We need to keep our trees. And they could have just forbid that, I presume, right? But that's pretty draconian. So the Forest Conservation Act's idea was, okay, if you're going to develop property, that's fine, but for those trees you're not going to save on your property, you got to conserve them somewhere else. You got to buy credits. You got to mitigate. You got to do things to address it. And so when the school comes along and says, we want to build a school, obviously our environmental team, our planning director, we're not able to say, oh, your school can only be 20 feet by 20 feet, or your school can only be this size. We have no idea or any expertise as to say what the size of a K through 8 school is going to be. And it's going to need a parking lot, and it's going to need a playground. Obviously, trees are going to have to be cut down. So when we review these tree conservation plans, and I made large copies of them so you could actually read them in my brief, because they're very difficult to read in the other stuff submitted in the record. You can see they're full of exacting technical analysis from the qualified professionals in our division and the landscape architect or the engineer who prepared the plans for the applicant that, you know, get down to like the caliper size needs to be this. Here's the tree root spread of this tree. Here's the area you have to preserve around it. I mean, they're like highly technical documents. And the reason why I think our argument at the time, why we thought maybe appeal wasn't appropriate here, is because this was much more to us like a building permit. So, you know, when you're living in your subdivision and your neighbor comes in to build a new house, and you look over there and you're like, is that thing gonna have sprinklers in it? You know, aren't they supposed to have sprinklers in there? Or I don't like the windows, you know. When a building permit comes along and you have to comply with the building code, those are issues between you and the government. The government's regulating your building, you have to do this stuff. The neighbor can't go like, I want more windows. I don't like the way you're meeting these requirements. That's what I think a tree conservation plan is.
Somebody would have had standing at some point to challenge that subdivision.
Oh, absolutely.
Right?
Absolutely.
And
way
so,
back at the beginning. Right. Yep.
So isn't, again, I'm
I
sorry,
can keep going because I can explain why there is a right to appeal now.
Well, and
There wasn't in 2021.
on the analogy of the building permit, a neighbor would have the right to challenge the issuance of a building permit, at least in as much to say that the county agencies are doing what they're supposed to, that this building permit meets all the criteria.
Sure.
But in the case of the forest conservation ordinance, it seems that particularly here where there's a provision that the only referral is to DNR, how does the public say, how does the public get the opportunity to say this deal is not rotten?
Right. It's been solved. So this is 2021 when I'm
solved
dealing
by
with this case.
bulldozing the trees?
No, the appeal process has been solved. 2021, we're looking at this. We have no guidance. We're like, how can a neighbor have the right to appeal? This doesn't seem to be the purpose of the act. Then the Westport case comes along and says, well, Hereford County, it looks like they gave neighbors the right to appeal. So we're going to say that there is a right to appeal. 2023, the General Assembly comes along and amends the Forest Conservation Act and now has given adjoining property owners the right to appeal. That has happened subsequent to this entire case occurring. And what it appears to me is the General Assembly said, hey, we never gave anybody the right to appeal. They should have the right to appeal. Now, the only problem I see with the right to appeal is that it's kind of like the Sheets case that the Supreme Court just approved, right? They said, hey, legislatively approved impact fees are also subject to nexus and rough proportionality. And everyone's like, all right, well, what is rough proportionality? Well, we'll let the courts figure that out. Well, that's kind of what they've done here. Your question is like, okay, we're going to give the neighbors the right to appeal these. What are they going to be able to appeal? The General Assembly didn't say what rights they have. I mean, the act was just supposed to replace the trees. It doesn't say anything like make sure that you keep a buffer along one side of the property so people don't have to. The sad thing is, in my opinion, may not reflect that of my client, is that because the school doesn't have to come in for zoning and subdivision approval, we couldn't impose any requirements like landscaping, buffering, and other things that would have addressed the problems the appellants clearly have with this development. We just didn't have that authority. All we could do is make sure that they replaced those trees that they were going to take down, and they did so.
And maybe that's the answer, right? I mean, all this Sturm und Drang, right? Like, if what they have the right to appeal is they have the right to appeal the approval insofar as it approves a plan that's got to comply with the Forest Conservation Act, right? Yeah. And, that's only going to go as far as the Conservation Act rights they have or don't have to enforce. And maybe the answer is, well, on the merits, that decision is reviewable for substantial evidence, and that's super deferential, and we all understand that probably nobody's happy, but we defer to the expertise of the agency. Like, that's classic administrative law. We spent the entire time together fighting about how we don't even get to talk about any of that.
Yeah, right.
Right? Your side's whole presentation here has been like, no, we don't talk about the merits. But now you're saying we can talk about the merits?
Well,
or they're too late.
We don't know. I don't think you can do so now. You know why? Because, excuse me, I don't mean to use a colloquialism there, but
use colloquial as you want. We're just trying to get to the answer.
Well, my feeling was when I was looking at my preparation for this case, I said, wait a minute. Before this court is a circuit court's decision not to grant a writ of administrative mandamus. So what I focused on, you deal with the moot issue, Ms. Moriarty, I'll deal with substantial right. And I said, you have to find that the circuit court abused their discretion when they found that these individuals had no substantial right that justified the issuance of the writ. And that's when I went to look at, well, what are the rights that they claim are being prejudiced here? And I looked at these affidavits that they submitted, and I go down the list, and I'm like, these are things that we could have addressed at zoning, but they just don't have anything the planning director could have done anything about when she was approving the tree conservation plan.
So, right, and that kind of gets us to the question I was asking your colleague a minute ago, which is, if these folks don't have substantial right under the to posture an administrative mandamus challenge, is there anybody in the world who does?
You're going to ask that question, so I planned ahead of time. And I said, he's going to ask me, then who does if they don't?
I asked her 25 times. It's a pretty good. It's a pretty good signal.
And that's when I started thinking, this is kind of like what the Supreme Court has done. They haven't really told us what rights they're going to have.
But I think what you were saying a minute ago about the absence of any ability to do anything on a zoning level because this is a public entity, that I hear that as, we would love to, and under other circumstances we might, but here we can't. And that there isn't anybody who has a substantial right because this is public, which is kind of where I ended up with your colleague. But
here's where I think you could. So I was trying to think of some examples. Let's say we were just blowing off our responsibilities to approve tree conservation plans. Or we were doing simply nothing, like there was nothing in the record. Someone spits an application out and we're like, stamp, good to go, we don't make any findings. I would think that at that point, whether you bring it'd be some type of mandamus action, because you'd be telling the public entity, hey, do your job. Right. I think that's where the neighbors would come in and have some kind of right. I just think here, we did our job. There's so much in the record to show that we did our job, and there's so much in the record to show how much time we took to consider all of the appellant's concerns and address them, that I think in this case, their rights have been protected.
And just, again, so I make sure I understand what you're saying, though, in all of that job doing, right, the result is the planning board having the hearing and listening, but ultimately the planning board had no authority to require anything.
No, not true.
Okay.
I think
What
what the planning board,
part did I miss?
what the planning board felt they had the right to do, the reason why the chair said, you know, I think we have the right to hear this case, is that we appoint the planning director. And so we feel when the planning director acts, we should have a right to review her work. And one of the members in there, Chairman, or Commissioner Dorner, discusses that in the transcript. It says, we have the right to review what the planning director says. Now, I don't think that's true. A lot of times they delegate full authority to the planning director, but nonetheless, that was what they thought. And so I think had they decided that day 3-2 the other way, they could have said, planning director, we don't like your findings, reevaluate, you know, we remanded, probably wouldn't call it a remand, would have said, take another look at this. This is not good. That's probably what would have happened.
Could the school district have gone and built the school anyway?
Well, they would have not been able to get their grading permit because the TCP
So
wouldn't
we
have
come
been
back to
issued
that.
yet. They need a TCP before they can issue the grading permit.
But they don't get that from the planning board. They get that from.
They get that from the county, but the county can't issue the grading permit unless there's an approved TCP. So they would have been withheld. And it's not the grading permit process that governs the appeal, which the appellants mentioned. It's the, if you have to get a grading permit, you need to get a tree conservation plan. And just the last thing I'll add, if you just give me a second, is just the practical effect of this. Kind of like you mentioned at the beginning. Our environmental planning group of 4 or 5 people reviews hundreds of tree conservation plans every year because every site plan, every preliminary plan, every grading permit for anything that's close to an acre has to get one. Sometimes you have developments that have to get 2, a TCP1 and a TCP2. We have hundreds of plans. So I don't think that the county thought every one of these plans could be appealed by a neighbor because that would just be overwhelming. But that's apparently what the state believes should be the right now.
Guess we'll find out.
Yeah.
Okay. Any other questions? All right. Thank you, sir.
Thank you.
All right, Ms. Votaw, you have 5 minutes.
Thank you, Your Honor. If I may, I think it might be helpful for me to walk through the process as we see it to answer your question of who can appeal, at what point can you appeal, what are you appealing?
I think he just recognized that you can appeal this.
Well, I was surprised by that statement.
So don't snatch defeat from the jaws of victory here.
I won't. So this is the process as we understand it, and we assert is the correct process. The Forest Conservation Act is a state statute which requires public entities and private entities to comply with. And the county's ordinance makes clear, even under mandatory referral, where a public agency is not required to get zoning approval, their entire project can be halted or prohibited based on the tree conservation plan alone. That's in the environmental technical manual itself. And in that case, in this case, for example, you have the tree conservation plan and the Forest Conservation Act variance reviewed by the county. The Craig Westport case tells us that the approval of a tree conservation plan and a Forest Conservation Act variance is a final appealable decision. That is the point at which you would appeal that decision. In fact, the Craig Westport court rejected the argument that you have to wait until you get to the grading permit before it can be reviewed. To answer your question is, when in the process is there an appeal or can the court review that decision? It's after the tree conservation plan has been approved. That's when the appeal process starts by, we argue, neighboring property owners. We get to the question of who can appeal. We believe that people who can appeal are people who satisfy the property owner agreement standards. So that's your nearby, and maybe you have some plus factors. There are specific reasons why changes to this property impact you different than someone who lives maybe 30 miles away. We believe we've established that through our affidavits. And again, the affidavits were not a list of the remedies we want from this court or a list of complaints in this court. It was a description of how in addition to the fact that they're adjoining property owners, they also meet the plus factors for property owner aggrievement because of these other impacts that this will have on their property. So we believe Our clients are the exact people who live adjoining to this property. We are exactly the people who can appeal this decision. And then I was surprised when Appellate Planning Board said that the people or the arguments that you can bring to challenge this is an argument that, hey, Planning Board, do your job. That is exactly why we brought this case. We are asking this court to say to the Planning Board, you have to do your job. You have to apply the uniqueness standard. You have to apply the unwarranted hardship standard.
Where's the uniqueness standard? The uniqueness is not mentioned in 25-119, but it is mentioned in 27-230. So how does uniqueness apply on this application?
We say it applies because the term special conditions peculiar to the property.
Well, they say peculiar, not unique.
Well, Maryland's case law says that that term means uniqueness.
But they use unique in the zoning ordinance, but not in the tree conservation ordinance. Peculiar to the land is taking a look at that particular piece of property in and of itself, as opposed to that particular piece of property in the context of other similar properties, which you would have under the zoning ordinance with the use of unique.
I would disagree slightly, and for these two reasons. The first is, if you look to another similar law, for example, the critical area law, which also uses the exact or almost identical language, peculiar to the property, conditions peculiar to the property, Maryland's case law have said, which would include the Prince George's County critical area law, that requires a showing of uniqueness. So for that reason alone, or again, that's why uniqueness is required. Furthermore, we would argue that there's no way to determine whether, or it would be very difficult to determine whether a condition is peculiar to the property if you don't look to any other property. Because it could be the case that every property in the area shares that peculiar condition. And in that case, Maryland's variance jurisprudence has told us that the appropriate remedy is not a variance, but instead the
zoning variance.
Well, critical area law as well.
This is not a, it's almost a neon sign in the ordinance that says this is not a zoning case, and the forest conservation statute seems to look at how the proposed use of what is the proposed use of the property in and of itself, rather than the effect of the use of the property on surrounding properties.
I would argue, I would disagree with that statement for the following reasons. Again, Maryland's land use jurisprudence is encompassing both zoning and critical area law. So if we're just going to look at critical area law, which was established at, I think, within a year of the Forest Conservation Act with similar goals, Maryland's critical area law has concluded that the term special conditions peculiar to the property, or substantially similar terms, requires a showing of uniqueness. And the reason that you have the uniqueness element is not necessarily to evaluate always in every circumstance impacts on other properties. It's to ensure that the requirements of the law are being properly enforced and are not being I don't want to say arbitrarily, but they're not being, the standard's not being lowered to meet the needs of all the property owners in the area. If what Maryland's, including critical area law, but generally land use case law describes is the variance is supposed to be a rare instance. Generally, there's a presumption against variances. That is true in zoning law, but it's also true in critical area law and is also true in Forest Conservation Act law. And because there's an assumption that a variance should not be approved, that they are limited for very rare circumstances where you have special conditions peculiar to the property or uniqueness of the property, that the assumption is that only a few properties would meet this criteria. It's for the rare circumstance where the state's legislation has not been able to think through every single permutation of when this would be applied. But the issue is, if you're not looking at whether other nearby properties share the same special or peculiar condition, the issue with that is then variances would be approved for all of those property owners. And Maryland's case law says that's not the appropriate remedy. If there are many properties that share the same peculiar condition, then the Appropriate remedy is to deny the variance because, again, the property would not be unique or would not have special conditions peculiar to that specific property. And instead, it would be up to the legislature to determine whether or not there should be legislative changes to when this would apply and when it should not apply. So again, we believe the uniqueness a requirement is required, both if you look at zoning case law, but specifically if you look at critical area case law, which similarly was developed through the analysis of or evaluation of similar zoning case law. But if I just may put one last point on it, Your Honor, or I've gone on. Okay. I just would, again, encourage, or I would urge this court to find that it has jurisdiction, find that this case is not moot, that there is a substantial right because we are property owners, and reach the merits of this case. It's an important case, and we thank you so much for your time.
Thanks to all of you. Case is submitted. We'll take up next case number 9.